Hello, I'm Dan Marr, and today, or this video, I'm going to be talking about claims of undue influence and mental capacity as to gift manipulation or inheritance manipulation, where there's claims that are saying that mom or dad or my aunt or uncle didn't want the inheritance or their property to go the way they did, and somebody exercised what's called undue influence, or they took advantage of somebody when they were mentally incapacitated. We'll talk about those claims. I've dealt with those quite a bit in my 35 years of legal career on all sides of the situation, and I'll be talking about those. Generally, when somebody's making a claim that there is a gift manipulation, the first one that might be made is that somebody is mentally incompetent. Mentally incompetency for gift manipulation is basically that the person doesn't understand what they're doing. And to prove that, they have to usually have some type of evidence there. It can be evidence, direct evidence from somebody that has seen them during the time that they're making these inheritance decisions. And also, there might be a review of medical records if there have been medical records by a mental health care person, a psychiatrist, or psychologist that will make some determinations. Often, I will have, when I'm dealing with a mental capacity issue, there will be experts that will be opining as to the opinion based upon what they were dealing with. Often, they won't have the opportunity to actually talk to the person because these claims are often made when the person is no longer with us. They've passed on, and the claims are being made by relatives that are disgruntled and displeased that they did not get what they thought they were going to get. One of the things that our estate planning people here do when they think that there might be such a claim, but they still want to provide some inheritance for one of their offspring, but they're also concerned that that offspring might be making challenges that the other offspring are getting more than they are, is to actually do what's called an interim or incontestability clause in the will or the trust, in which they take an opportunity where they say that if you challenge this, you get nothing. So if you challenge and are unsuccessful, you get nothing. Obviously, if you have a will or a trust that says if you challenge this, then you get nothing, and you challenge it and you prove that the person had lack of mental capacity or they were subject to what we call undue influence, then that will or that has the incontestability clause, or interim clause, is void. So it doesn't matter to you. So you have to be in a situation where you actually, the old saying is, if you shoot the king, you better kill him. It's an all or nothing proposition for you. And in that situation, if you're going to be using an interim clause as your own person, you're thinking about your will and you're thinking, okay, I have 5 children and one of my children is estranged from me, but I know he or she's going to fight. They're litigious, and I don't want my other 4 to be having to deal with that fight, even though I want to leave most of my inheritance to those 4. You want to leave enough to that 5th person if you're doing this interim clause, if you're using that provision, so they have skin in the game. You got something to lose. All right, so the other kids are getting $500,000. I'm getting $50,000. But if I lose, I get 0. So I get 0 or $50,000. Well, now I have skin in the game, and I have to actually think about, do I make that challenge? How do I go about this? Because $50,000 is more than 0, and I want to consider that aspect of it. So that's something that somebody that's doing their own estate planning can deal with. But if it's not that person that's doing the estate planning, it's just siblings perhaps challenging. And I'll tell you that usually it's after the last to die, the siblings often will, if they're get estranged from each other, they didn't have the best relationship growing up, they'll rally for the surviving parent, but when the last of the parents go, that's when the fights go. Sometimes it's different than that, but often that's the case in my experience from what I've seen both in New Hampshire and Massachusetts. I've dealt with litigation in both because I'm licensed in practice in both Commonwealth of Massachusetts and the state of New Hampshire. So in that situation, the challenges that are made of mental capacity are really that you don't know what you're doing, and you don't understand what your general assets are. You don't generally understand who would be the beneficiaries of your assets. You don't know who your children are. You don't know who your wife is or your husband are. Those situations you have a mental capacity lapse, and that's a tougher one to prove, but it does happen. Sometimes people with dementia don't have that capacity. A question on mental capacity, though, is when the estate planning was done. There are people that have mental capacity in the morning and don't have it in the evening, or vice versa. During the particular period of day, they may be lucid, and if they're signing the documents when they're lucid, then they have a state. Then they've met the mental capacity requirement, and the other side challenging it, showing that look, in this situation they were having hallucinations. They could have hallucinations in the same day. Maybe they're sundowning, and that's a term that people that have some mental capacity issues or mental concerns will have more difficult time when the sun goes down, and they call it sundowning in the memory care unit sometimes. And you can still have capacity at one point in time of the day and not have capacity at another portion of the day. So that's an issue. The more tougher arguments are what's called undue influence. Undue influence doesn't rest on the person can't sign any contracts. They don't know who the president of the United States is. They don't know who their children are. They don't know what assets they generally have. They don't have that capacity. This is really, they do have that capacity, but they rely on this one person completely. Or maybe that person has lied to them. If somebody is saying, by way of example, the only reason they don't want to go into a nursing home and they're staying in their family home, and their son or daughter living with them and saying, if you don't give me more than my siblings are going to get, I'm just going to walk away and you're going to go into a nursing home because my siblings are all across the country and I'm the only one here. I'm the only one keeping you out of a nursing home, Mom, so you better be doing this. If that's actually proved to be the case, then in that situation you might have undue influence. That's different than daughter loves mom and daughter's taking care of mom and daughter's not making those types of threats. And mom decides that because daughter is the one who's taking care of him and the two sons are in Alaska and California respectively, and even though they're nice people, they're not the ones that are living through all the traumas and taking her to all the hospital visits and doing all the difficulties that they're having right to the end of life. If that's the situation, that's not undue influence. That's influence, just like I'm influenced by somebody when somebody gives me an opportunity for an apple or pear to eat, and I'm making a decision there. Somebody might go and say, have the pear, it's better for you, or apple is better for you, or whatever it may be. That's not undue influence. Undue influence under the law is actually usurping your own free will. It's at that level. Somebody, and again, it could be by threats, it could be by lies to somebody. It could be that you completely rely on this person to do everything, your groceries and everything else, and you know that if you don't give them what they want, then they are going to leave you and you're going to be in a bad situation. So you can be in that. And often with undue influence, there's a variety of isolation where, say, and I'm picking on a daughter, could be equally a son, of course, but the daughter that's living with them is preventing the other children from talking to mom. She's always making an excuse for that. Mom used to love to do some social events with other people, but daughter won't allow that to happen anymore. So she doesn't get out to go out to lunch or dinner with some friends of hers that she still wanted to keep in touch with. Daughter is controlling every aspect of mom's life so that she can manipulate her into giving her what she wants. In that situation, that can be proven to be undue influence. I've had a situation where I had several years ago, 12 years ago, I had a trial where there was a caregiver where mom passed on. Father didn't want to be in assisted living because he didn't need to be in assisted living. He was only there because of his incapacitated wife, and when she passed, he didn't want to be there. And he had a platonic relationship with somebody that was 20 years younger than him. and he lived with her in a 55 and over facility. The daughter later brought a claim after he had passed on that that she had taken advantage and undue influence on him. I was able to prove in that case that he did all his banking online. He did all his estate planning activities online. He decided where to put his bank accounts, and when he was putting his bank accounts into survivor rights to her, he knew what he was doing, and he was the one who was making all those decisions. And we had a 5-day trial, 5.5-day trial, and 5 days and then a half day worth of videotaped depositions that were submitted to the court. And the court made the determination that while she was certainly there because of, she probably wouldn't have loved him if he was homeless and he didn't have any money, it was a mutually beneficial relationship. He wanted somebody there to take care of her, to prevent him, or take care of him to prevent him from going into a nursing home. And she probably wanted somebody that was financially well off enough to take care of her. And in second relationships, there can be that mutual self-centered relationship of not love anymore. It's more of the self-centeredness, and that self-centeredness is allowed. So in that situation, I was able to prove that during this circumstance, right down to where the judge found that sometimes his spending habits, which were much more enhanced, he was spending more after he had a relationship with her, a platonic relationship with her, that he had an interest, he had a sense of his own mortality, and he understood that. And also right down to the funny facts of they went out a lot more because he didn't cook, and she was a horrible cook. She could burn water. So, and the people in the 55 and over community dealt with it. I went through and talked to all the neighbors. The other side didn't, and I got exactly what was going on, and they were very he was very frustrated that his daughter wasn't coming and seeing him, and she didn't like the fact that he took up with somebody that was 20 years younger than him after mom passed away. That was some hurt feelings going on there. But also I was able in cross-examination to ask her, well, if you're so concerned, why weren't you checking in to make sure that she wasn't taking advantage of him while he was still alive? Why did you wait until death? And that type of information, that factual information, is important. So you got to dig into the facts of the case, and you got to have a lawyer that's dealt with these issues before on both sides. I've dealt with both sides. I've prosecuted the undue influence claims in a civil case as well. So very fact specific. You want to talk to a lawyer that knows what you're dealing with this stuff, and you also want to understand what the full nature of the estate plan is, including what goes outside of the wills and trusts and what goes in through the wills, like what goes through bank account statements, through survivorship rights, and the like. So we can talk all about that. If you have such an issue, I'm here at 603-883-5501 Hamblett, Kerrigan. You can check out our website also at hamker.com or NashvilleAllOneWord.com. Thank you.